Hey guys, welcome back to the channel. Today we are going to talk about something crucial for both borrowers and lenders. The top 5 most important clauses to look out for in loan agreements. Whether you are a business owner taking out a loan or someone lending money, these clauses can have a huge impact on your financial position. One of the key clauses to be aware of in any loan agreement is the default interest clause. So what does this mean? In simple terms, this clause kicks in when the borrower fails to make repayments on time. Once a borrower defaults, the lender can then impose a higher interest rate on the amounts overdue. This could be significantly higher than the regular interest rate, and in some cases, it can compound, causing the debt to balloon quickly. For borrowers, this clause can create a financial burden in the event of a missed payment. For lenders, it's a safeguard to ensure timely repayment. Always check the default interest rate and see how it's calculated. Some loan agreements have high penalty rates, and understanding this in advance can save you from a world of pain later on. Next up is the acceleration of repayment clause, which is a critical term that often catches borrowers off guard. Here's how it works. If a borrower defaults on any payments or breaches any part of the loan agreement, the lender can demand that the entire loan amount be repaid immediately in one lump sum. This means that instead of continuing with the monthly or scheduled repayments, the full loan amount plus interest becomes due and payable immediately. This can be particularly devastating if you are a borrower struggling to make ends meet. For lenders, this clause is a key enforcement tool to recover the full loan quickly if things go wrong with the borrower. Therefore, always check under what circumstances the acceleration clause can be triggered. Some agreements allow acceleration even for minor breaches. You don't want to be in a situation where missing one payment leads to the entire loan being due. Now let's move on to the prepayment penalty clause. While you might think paying off a loan early is a good thing, lenders sometimes see it differently. Many loan agreements include penalties if you decide to pay off the loan ahead of schedule. Why? Because lenders make money from the interest that you pay over time. Paying the loan early means that they lose out on this future interest income. So a prepayment penalty compensates the lender for the loss of the future interest repayments. If you're considering refinancing or anticipate having extra funds to pay off the loan earlier, be sure to review this clause carefully. You don't want to be hit with an unexpected fee for being financially responsible. The fourth most important clause is the collateral or security clause, especially in secured loans. In these agreements, the borrower often offers assets such as property, vehicles, or business assets as collateral for the loan. If the borrower then defaults, the lender has the right to seize and sell the collateral to recover the outstanding loan amount. So for borrowers, the key here is to know exactly what's at risk. Understand what assets are tied to the loan and whether there's any flexibility in using alternative forms of security. Here's a pro tip. If this is the loan amount, make sure that the value of the collateral isn't disproportionately high compared to the loan amount. Otherwise, you might lose assets that is worth far more than the loan itself if things go south. Lastly, we have the event of default clause. This is one of the most detailed and comprehensive clauses in loan agreements, outlining the specific situation that would be considered a default. It's not just about missing a payment. This clause may include financial covenants like maintaining a certain cash flow, changes in ownership structures such as a change in shareholding or sale of shares, or even bankruptcy or having a writ of summons, being sued, that kind of stuff. You need to understand the triggers for default because they can vary widely. In some cases, even a technical default such as providing financial statements late, can trigger penalties or acceleration of the loan. For lenders, the event of default clause provides more control and protection, but for borrowers, it's a potential minefield. So take the time to read the loan agreement carefully, especially the event of default clause. Whether you're signing a loan agreement for personal or business reasons, always read the fine print, and if in doubt, consult a lawyer. These clauses can have significant financial implications, so it's crucial to understand them upfront. Thanks for watching this video, and I'll see you next time.